Hello, my name is Grainne Feeney. I'm a partner in the private client teams at Anthony Gold Solicitors. I deal with court of protection matters, wills, trusts and estates. Today we're going to discuss the difference between a deputy and an attorney. Lasting powers of attorney and deputyship orders are legal mechanisms by which an appointed person can make decisions on behalf of a person who lacks mental capacity. The type of decisions include dealing with their property and affairs and/or health and welfare. LPAs can only be made by a person before they lose mental capacity. The individual, known formally as the donor, makes a fully informed choice about who they want to act on their behalf should they lose mental capacity at some point in the future. It is a useful preparatory step to take and allows an individual greater control to decide who they would like to act as their attorney, such as a relative, friend, or whether a professional should be appointed to act instead. The individual is also able to set out exactly which decisions they would like their chosen attorney to make on their behalf, and they can set out any restrictions on their decision-making powers as well. Forms are completed, and once executed, the LPA is registered with the Office for the Public Guardian. An LPA for property and affairs can be used prior to the donor losing capacity unless that is specifically restricted. By contrast, an LPA for welfare can only be used when the donor no longer has capacity to make decisions in relation to their welfare. A deputy is the alternative option where there is evidence of lack of capacity and no LPA has been executed and registered. A deputy is appointed by the Court of Protection. An application to the court will need to be made by a third party on behalf of any individual who lacks capacity. A deputy will be required where no other provision has been made to deal with an incapacitated person's affairs. The application is made to the court and is often presented by a third party, such as a family member, friends, social services, or a professional advisor such as a solicitor. The application process is a formal one and requires the person making the application to file evidence on capacity. It is important to ensure that the evidence is presented in accordance with the Mental Capacity Act 2005 and that the person applying to be appointed as deputy is suitable. There is a deputy declaration which must be completed as part of the application and standards which a deputy should meet, as set out by the Office of the Public Guardian, the supervisory body.